All right. Well, welcome everybody. I am attorney Justin Randall with Hooper Law Office, and today we're going to be talking about, as part of our ongoing series of, keeping your gold in your golden years, or maximizing retirement value for you and your family. We're going to be talking about long-term care expenses in particular, and various ways that you can potentially plan for those expenses, or if you have other concerns related to those expenses, how you might, if you're not looking into insurance or you're concerned about having enough to pay for your care, other tools available to you as well. And just a couple quick items before I go into detail on things. But as always, this is an interactive webinar, so you can submit questions to the Q&A function. I'll see those come in. This in particular is a pretty complicated topic, and there's a lot of details. So I'll try to get into as much of it as I can in our short, half hour that we have. But if you have any questions in relation to that are coming up as I'm going, please feel free to submit them. And then keep an eye out at the end of this for an email, which will include a feedback form from us, which does a couple of things. Of course, you can give feedback on it. And I promise I have thick skin, so if you have constructive criticism, that's okay. But it also gives you a place to let us know that you'd like to come in and talk with one of our attorneys for an initial consultation. Those initial consultations are complimentary, so they don't cost anything to come in and initially meet with us. We schedule them for about 2 hours, give or take, to really get time, have enough time to go through everything that you bring in and your questions that you might have, and give you a really good recommendation by the end of that. Especially if you have a loved one who might be needing care soon, or you're concerned about that, absolutely make use of that. It's well worth your while. And then you'll also receive a handout from us, which kind of talks about the different levels of care that somebody might receive in terms of long-term care. Long-term care is not just one thing. It can be a variety of different types of care, ranging from, on the lower end, maybe at-home care, where they have someone coming in a couple hours a week, to skilled nursing level care, which is usually the most expensive, where people are thinking about like nursing home specifically, and the various things in between. So it can be really helpful for you to understand what those different cares are, and also the different potential costs associated with those levels of care. Getting started on that, when we're talking about long-term care expenses, we're not talking about like long-term disability. I hear that question a lot of, well, I have like long-term disability insurance through work, or I have, AFLAC, right, that pays if I can't work for some reason. That's not what this is. Long-term care is specifically at-home care, assisted living level care, memory care, or skilled nursing care. We're not talking about somebody who might just have a disability preventing them from working. Of course, they may also have that, but this is specifically a type of care, normally for people who might be later in life, or have significant physical needs, or potentially have like memory care, like Alzheimer's or dementia. And there are a variety of costs associated with this, or a variety of ranges of costs. And so I mentioned at-home care sort of being the lower end of care in terms of need. Of course, somebody, I suppose, could be paying for at-home care, even for a very high level of need. It's just going to be a lot more expensive, because you're usually paying by the hour. That hourly rate is going to vary, of course, but it's generally in our area, what we're seeing is give or take about $32 an hour or higher. So you do the math on that, a couple hours a week, it's maybe not too bad, a couple hours a day, even not too bad. But if you actually need round-the-clock care, at-home care can be the most expensive type of care you can receive. If you run the numbers on that and you do 24-hour around-the-clock care at that rate, you exceed the cost on average of a skilled nursing facility even. So it's a great starting point for a lot of people, and a great place to be if it's possible. But if you need the level of care you would receive in a skilled nursing facility, it's probably not the most cost efficient for you either. We always look at, or use as an example of like the Bill Gates of the world, the billionaires of the world. Yeah, they're not going to have any problem paying for that, but most of us can't, because it's very expensive at that point. Usually, though, after somebody can't receive at-home care anymore, it's starting to become too expensive. That's when they're looking at assisted living first. And that probably has the largest range in cost. You can see on the lower end of assisted living, somebody might be receiving care for $4,500 a month $5,000 a month on the lower end. But if they need memory care type care, and what I mean by that again is Alzheimer's or dementia or some, other sort of memory care diagnosis, sometimes related to like Parkinson's, right? That type of care can be routinely $7,000 to $8,000 a month on the upper end. So it's still pretty expensive. It's not that it's cheaper than skilled nursing on the lower end of skilled nursing sometimes either. But skilled nursing, that's what most people would think of as a nursing home, and like the more traditional sense of a nursing home, not the assisted living component. And that nowadays we're seeing routinely $10,000 to $11,000 a month for that level of care. So it's usually the most expensive. Most people are not going into skilled nursing right away, or if they are, it's not for a very long period of time. That's where you hear the statistics sometimes of it being, 2 years on average of that level of care. Where people do tend to receive care for longer periods of time, though, is the assisted living level of care, because especially if it's memory care, and depending on the person's age, they may be receiving care for a decade or longer, especially early onset Alzheimer's, right? Somebody in there, maybe in their mid 60s going into care, might be receiving care for a long time. So this can be expensive. If you run that out over a year, $8,000 a month is $96,000 a year. $11,000 a month is, over $120,000. So you're really looking at a lot of expense coming out of pocket. And it's great if you have the income to cover that. And some people do in retirement, but most don't. So the first way you can pay for your care, of course, is if you have the income for it. If you're covering it out of income, that's great. We don't focus a whole lot on that because it's not really a common strategy, or not a common option for most people in retirement. Most retirees are below that in terms of income, or it would be at the very least eating up all of their income, and they're using their other assets for other sort of expenses that they have. So when you go into care, the first thing people are concerned about is, well, how am I going to pay for this? And like I said, income and assets, if you just have $1 billion like Bill Gates, then, or billions of dollars like Bill Gates, you're not going to be worried about covering those expenses. But you either use your income or your assets first. A lot of people are concerned about whether or not Medicare will cover those expenses. Medicare will only cover about 100 days of a rehabilitative stay at a facility. So what I mean by that is, somebody's getting their hip replaced and has to stay in a nursing home afterwards for rehab purposes, to kind of get back to where they were prior to the surgery, or as close as they could prior to that surgery. Medicare will cover about 100 days of that stay. It's about 100 days because they don't cover the full value of that 100 days either. But if you're there permanently, or it doesn't look like you're going to be coming home, they will often try to end that coverage sooner, because they don't cover long-term stays at a skilled nursing facility or an assisted living facility. So at that point, that's where you're privately paying out of pocket. And that's where I'm talking about somebody who would use their income or their assets to pay for care. So if that's a concern, or it doesn't look like you have enough in assets to pay for care indefinitely, or maybe just for a couple of years, and you're concerned about what happens at the end of that, there are different things you can do to plan for that expense. First and foremost, one of the first things that we ask if somebody has or has looked into is long-term care insurance. And this is where people often get this confused with like AFLAC or long-term disability insurance. But long-term care insurance is insurance that specifically covers at-home care, assisted living care, or skilled nursing level care. And they usually have a set amount per day that they'll cover, and they set maximum value or set period of time maximum that they'll cover. So on average, I see a lot of these cover like 3 years of care, 4 years of care, or $300,000 total. And it varies depending on your policy, but that's the kind of coverage you're looking at. So with these policies, though, they can be expensive. And what you want to do, if you haven't looked into this yourself, is look into it and not necessarily listen to like what somebody online said about it, or what it cost your neighbor or your family member, because you need to look at it for yourself to really know what it's going to cost you, and whether or not you look at that as a reasonable expense. What's expensive, or what the kind of the definition of expensive, varies per person, right? What one person might view as too expensive, another might view as reasonable, given their circumstances. So you want to look into this if you haven't. although there are sort of ideal times to look at this, and they can look into your health as well and see if they would just outright deny coverage for you. So generally speaking, you're going to want to look at this in your early to later 50s is kind of the ideal time frame. You can look into it into your 60s, into your later 60s. I suppose you could even look into it into your 70s, but that's just where the cost starts to become prohibitive almost. It's very expensive at that point. And depending on your prior health history, if you have a family history of Alzheimer's, or you currently have Alzheimer's, they're either going to, increase that cost substantially for you, or in the case of somebody who has a diagnosis, they probably won't cover that person at all. So it's worth looking into, but it's not an option for everybody. The reason it's important, though, to either be able to privately pay or have long-term care insurance to help you do so is a lot of facilities are looking at 1 to 2 years on average, sometimes 2 to 3 years of private payment being required before they'll allow someone who's on Medicaid to stay there. So they'll ask a family, hey, show us that you can pay 2 years, or show us that you can pay 3 years out of pocket before you would apply for Medicaid. Otherwise, we don't have to keep you here. And so that is something that you want that coverage for. And long-term care insurance can be a really good tool for that if you don't have the other assets to do it. Maybe you can self-fund again, and that's great if you can, but not everybody can. And it can be a really helpful tool even if you can self-fund, because then you're just protecting more of your own assets from having to be spent on care. There are a variety of these policies out there. There's sort of traditional, where it's you either use it or you don't. There's some hybrid policies that are like insurance-based. They pay out a death benefit that if you didn't use it all, you get some of that money back, right? Or if you didn't use any of it, you get the death benefit out of the policy. So, look into it, talk to your advisors on this, your financial planning, advisors, maybe insurance advisors as well. Talk to them about this and see if it's a good fit for you. If you've already looked into it and it's not something that was a good fit, that's when we're looking at either Medicaid or for veterans or the surviving spouses of wartime veterans, the VA's improved pension program to help pay for care. So in order to qualify for Medicaid, though, they have asset limitations and income limitations on what you can have in order to actually receive that benefit. When you're looking at Medicaid, for a single person, it's pretty straightforward. One, your income has to be less than your cost of care. If your cost of care is less than your income, you're not going to qualify for Medicaid, which, again, is better to be able to cover your care than not. But in order to get Medicaid, doesn't matter your assets. If your income is higher than your cost of care, you're not going to qualify. But asset-wise, for a single person, they can have no more than $2,000 in assets, and the home that they may own, their primary residence, they don't necessarily have to sell it right away. But this is where you hear people talk about the nursing home taking the home. What they're really referring to is Medicaid's lien on the home as they provide care. So eventually the equity in the home can be eaten up by the cost of care over time. And so it's not the nursing home taking the home, it's Medicaid's lien taking the value of the home at death or when that home is sold. The single person can also have, on top of those $2,000 in assets, one vehicle of any value. So it doesn't matter if it's an $80,000 car, $100,000 car, or a $20,000 car. You can have one vehicle. You can have prepaid burial coverage of up to about $15,000 for yourself, for immediate family members like children. You can prepay burial expenses and they won't count that against you. The $15,000 is an about $15,000 limit because there's not a set amount. That's just when they start to really scrutinize it a little more closely. When you're, if you're going over that, if you're substantially over that, they're going to say that's not a reasonable amount. So you want to be careful about how much you've prepaid. I mean, $15,000 is kind of the agreed upon limit amongst elder law practitioners. You'll hear that number quite a bit. And then in terms of life insurance, the single individual can have life insurance total amongst all policies of not more than $1,500, so $1,500 in face value. If they have more than that, which of course, when you have life insurance, most people do. Most people have more than $1,500 in policies, unless it's only like a credit union policy. Then they look at the cash value that you may have tied to those policies as something that you would have to count towards your $2,000 that you get to keep, or you'd have to spend down to that limit. So for a single person, all the other things like bank accounts, retirement accounts, additional real estate, all of that's available for care, meaning it has to all be spent down to that $2,000 limit if you're single. If you are a married individual and one of your spouses goes into care, but you yourself are living at home or are not in need of care, you get to keep substantially more in assets, or potentially substantially more. So the spouse living at home, what we would refer to as the community spouse, can keep their primary residence. There's no lien being placed on it this time if they're still living in it. So for a healthy spouse living at home, the home is not available for the other spouse's care. Now, additional real estate still would be, it would still be countable, but the primary residence would not be. The spouse living at home can also keep any qualified retirement accounts. So IRAs, 403Bs, 401Ks, any of those types of accounts, whether they're traditional or Roth, that are in their name. So the spouse's retirement accounts are still subject to that spouse's care, but their retirement accounts, when they're the healthy spouse, are exempt. So this can either be really good or really bad, depending on how that breakdown is amongst the spouses. If one spouse has substantially more in those accounts than the other, that's a risk for that spouse if they need care first, because then more would be at risk than if they were the healthy spouse. If they're relatively equal, it's kind of an equal risk. But yeah, I mean, a lot of times, especially with the older generations that we've seen, or like the kind of current generation going into care, it's starting to change, thankfully, but you'd see significantly more in one spouse's IRA or 401k than the others. And if that spouse goes into care first, it's a lot more at risk. So the healthy spouse, community spouse, gets to keep their retirement accounts. The same limitations apply on like the life insurance for that community spouse. The vehicle exemption still applies, and the burial amount still applies. So those are still protected for that healthy spouse as well, and for the spouse who's in care, for the insurance and burial. But then on top of that, they pool all of the other available assets together. So things like additional real estate, the retirement accounts of the spouse who's in care, any bank accounts, whether they're joint or individual, the cash value of those life insurance policies, all the other assets, they pool up together in value and say you still only get to keep so much of that as the spouse living at home. And how they figure out how much you get to keep is they divide whatever that value is in half. And if that half is $50,000 or less, you keep $50,000 of that. That's your minimum they can force you to spend down to as the community spouse. Again, only of the available assets. So that wouldn't be including the primary residence. That wouldn't be including your retirement accounts if you're the healthy spouse, or the other exempt assets. It's just of the assets that they say you do have to spend on care. But the most that a community spouse can keep of the available assets is currently about $148,000. And if that half falls somewhere within that range, you keep whatever that half is. So minimum $50,000. So if you are already below $50,000 in total assets as a married couple, one spouse goes into care, you're probably going to be immediately Medicaid eligible. But if I had $1 million in available assets, they're not telling me I get to keep $500,000. I still have to spend down to that $148,000 before my spouse can receive Medicaid assistance. So it's really, it depends on how much you have in available assets to determine how much you actually get to keep as a community spouse too. So on top of that $148,000 though, a community spouse may have a couple $100,000 or $1 million in their retirement account that they also have off the table. So what that looks like for you is really going to depend not just on how much money you have, but where you have that money and how you hold that money. Now, in terms of income, the community spouse, the one living at home, regardless of how much income they're making, they get to keep all income coming in their name. So it could, in theory, be higher than their spouse's cost of care. They get to keep it as long as it's their income. If they are below about $3,000, give or take, a month in income for themselves, they can shift some of the spouse who's in care, some of their income over to themselves. up to that $3,000 amount. So in theory, they could keep all of that spouse's income or maybe some of it, depending on where they fall in terms of income. Now, a single person or the spouse who's in care can only keep $45 a month of their income. The rest of it has to go towards the cost of care as a single person, or has to be shifted over to the community spouse, or again, to the cost of care if there's any other overage. So the person in care can only keep $45 a month while receiving Medicaid. That's what they call their personal needs allowance, which has obviously not been adjusted for inflation since that became a thing, because $45 a month doesn't cover a whole lot or really anything anymore. And that $2,000 limit is also not been adjusted for inflation. Now, the upper limit, that 148 roughly that I mentioned, that goes up every year for cost of living, inflation, things like that. So, and just a few years ago, it was about $130,000. So obviously, though, that can still be a lot of spend down for somebody to get to that point. They may have to spend through a lot of assets, especially for a single person. So people are often concerned about, well, how do we plan for this? How do we protect things from having to be spent down on that? And I'll get into that in a little bit. The other program I mentioned was the VA's Improved Pension Program. So what this program is a program for wartime veterans or the surviving spouses of wartime veterans. In order to qualify as a wartime veteran, the VA has very specific dates that you have to have served. So they have those set, like set by law. So they're a little different though than you might expect. Just to give you an idea, somebody who could have served in before December 31st, rather, of 1946. And as long as they were active duty for at least 90 days, and at least one of those 90 days was prior to that December 31st of 1946, doesn't matter if the rest of the 89 were after it, then they're a World War II veteran. So it's not always lining up with the history textbook dates that you might expect. So just because you don't think you are, or you weren't in a theater of combat, that doesn't matter. As long as you were active duty for at least 90 days for so reasons other than training, you were actually active duty. If you were in the reserves and you were active duty, you can still qualify. But if you were not active duty or called up, then you don't qualify as a wartime veteran. But again, it doesn't matter whether you're in a theater of combat or like here in Wisconsin, you can still qualify as a wartime veteran if you were active duty for at least 90 days. And some of those 90 days were during a wartime period. The last service qualification is you could not have been dishonorably discharged. So anything other than a dishonorable discharge, you're still considered a wartime veteran and eligible for these benefits potentially. If you served post 1980, that 90 days does go up to 2 years because there are no set wartime dates after 1980 at this point. And they've considered us to be at a relatively consistent or constant state of war. Whether it's a Desert Storm or Iraq or Afghanistan, right? Those people who have served during that period of time, if they served for at least 2 years, are still a wartime veteran. Now, this is a benefit also for the surviving spouse too. So if your spouse qualified and they've passed away, you as a survivor may still qualify for this benefit too. So this, unlike Medicaid, is a direct pension benefit to the wartime veteran or their surviving spouse. Whereas Medicaid pays the facility directly, this benefit pays you, and it's not necessarily even tied to care, it's more income based. So the how much the pension will pay depends on where you fall, whether you're a married wartime veteran, you're a wartime veteran married to another wartime veteran, or a surviving spouse of a wartime veteran, and how many dependents you have and what level of care you need. So it ranges. But like on the upper end for a wartime veteran who is receiving care, they could receive close to $2,800 a month potentially from this benefit. Whereas a surviving spouse who's in higher level of care might receive $1,400 a month. So they receive less, but it's still a benefit for them to receive. How much of that pension they actually get depends on what their income is. So if I was making more in income as a wartime veteran than what my maximum pension could be, I get nothing because you can't go lower than zero. They're not going to force you to pay it in, but they deduct your income from the max pension amount. Where this can be very helpful though for long-term care is the VA deducts from the calculation of your own income, your unreimbursed medical expenses. So when most of us are paying for long-term care, that generally exceeds most people's income in terms of unreimbursed expenses. So then for VA purposes, you have $0 in income, which means that in a care setting, a lot of times a veteran could qualify income-wise for the max amount they're allowed. And it can be really used as a way to help privately pay longer or indefinitely for some people. It can be used as a way to at least, lower the rate of spend down and make assets last longer. It can buy people some time, right? Just like Medicaid, they have some asset limitations as well, though. And they try to mirror what Medicaid had for their amounts, but it's, of course, a little different. So whether you're married or single, it's the same for this VA benefit, but you can keep the primary residence. That's not an available asset, not a countable asset, and up to 2 acres of land surrounding the home. So what that means is if you have more than 2 acres of land around the home, depending on your local zoning laws and what the minimum lot size is, you may have additional land that counts against you for this, for the max amount you can keep. Unlike Medicaid, they don't really have any other exempt assets. So what that means is retirement accounts, even of a healthy spouse, additional real estate, the extra acreage potentially, right? Cash value of life insurance, all of those things counts. And the max that the VA allows that person to have is $150,000 between, either themselves and their spouse. And there's no like lower end of that. They just have an upper cap on that. So it's a little more straightforward, but there are some minor differences than from Medicaid and what is and is not protected. And really, there's really only the home and 2 acres of land are protected from that $150,000 calculation. So some veterans don't qualify for this just because they're too high in other assets, especially if they have a lot of those assets in retirement accounts. Can be potentially difficult for them to ever qualify for this, but it's something to be aware of and something to keep an open mind on if you served during a wartime period or your spouse did. Now, both of those programs, Medicaid and the VA's Improved Pension Program, have what we would refer to as a look back period. So what that means is if you transferred assets away, you gifted things to the kids, you sold it for less than fair market value, you tried to put it into an irrevocable trust to get it off of the calculation, or out of the calculation. If you did it within the previous 5 years for Medicaid before the date of application, or the previous 3 years for the VA before the date of application, that is that look back period, and you have a penalty for that transfer. So the penalty is a period of time you won't receive these benefits. It's not like pay us back the money. Or you have a fine. It's that the Medicaid or the VA will not cover those benefits for a certain period of time. And how long that period of time is depends on how much you've gifted away over that period of time too. So the more you've gifted away, the higher the penalty, right? So you need to be very careful when you're trying to plan around these benefits, because a lot of times people create these issues for themselves without realizing it. They pay a family member for care without, for providing at-home care for them without having a caregiver agreement in place, or they put the home in the kid's name thinking that it will be okay, or they gift, within the gift tax amount. This is a really common mistake that people make and one to really call out, but there is no amount for Medicaid or the VA that you can gift, in terms of a certain amount that is okay. So the IRS says you can gift $17,000 per person per year without having to file a gift tax return. That does not mean, though, that those gifts will not count against you for Medicaid, because they absolutely will. There are some exceptions to gifting, but they're very narrow and you have to be very careful, and you certainly don't really want to rely on them as a way to prospectively plan. So don't think you're getting around these look back periods by gifting within a certain amount. Just be very careful. But when we're looking at trying to prospectively plan ahead for these benefits and help people set aside assets so that when they're on the $45 a month in income, their family may be able to help supplement their care needs, maybe things they want, or things that certain brands of things, or maybe the private room at the facility, whatever it is that Medicaid itself is not covering, or the VA isn't paying enough to cover, they may want to receive some additional support from family members. And that's often why people set aside money, so that the kids can do that. But it's a risk to give those things directly to the children in most circumstances. So when you gift an asset, and I'll use the home as an example, to your family members, you are, you put it in their name, they become the owner of that property. The problem with that is if you don't need care yet and you're still living at home, and you no longer own your own property, those children hopefully wouldn't do this, but they could evict you, charge you rent, sell the property without your permission, right? They're the owners now and you're a tenant at that point. Another problem people often run into with that is they continue to pay the property taxes on the property. But if you have Medicaid or VA coming up at some point and they see that you were paying somebody else's property taxes all those years, they're going to count that as a gift because you were under no obligation to do that. But really the bigger risks with putting any sort of asset, but real estate as well, into the kid's name is it's bad tax planning. Now, if you transfer your real estate over to the kids, they get your cost basis in the property if they didn't purchase it from you. Cost basis is how the IRS figures out how much of a capital gain somebody owes when they sell the property. So if you bought your home a long time ago, gift it over to the kids, and then they sell it after you pass away, there's likely to be some substantial capital gains tax for them to pay on it. And that can range from 15 to 20%. And if you inherit the property instead, or you leave the property to them through an inheritance, they get an adjustment of that cost basis up to fair market value. So if I inherit property from my parents, I can sell it with little to no capital gains tax. But if they gift it over to me and then I sell it decades down the road or years down the road even, I'm going to have a capital gains tax problem. Now, when you sell your primary residence, you get an exclusion from capital gains of up to $250,000 per person who is the owner of the home and has it as their primary residence. And that's as long as you lived there for 2 of the last 5 years. A lot of times the kids haven't done that. And so I'm running short on time here. So just a couple other quick things I'll go through first. But the biggest risk when you gift assets over to the kids directly and put it in their name is whatever happens to the owner of an asset happens to that asset. So if they pass away, they get sued, they file for divorce, file for bankruptcy. These sorts of things can be available for those issues. So you don't want to protect these assets from your care just to open it up to other people's liabilities. So the better way to try to plan around this, if you're doing it prospectively, is to often use irrevocable trusts. And the reason for that is the kids don't own the trust. They may act as the trustees, but they don't own that trust. So their personal liabilities don't apply to that asset. They're more like property managers rather than owners. It's still part of your estate. So when you pass away, they get that tax basis adjustment where it can wipe out capital gains tax. And in the meantime, because they don't, because you have an obligation through that trust to continue paying property taxes, the kids also have an obligation to keep allowing you to live in the home and can't sell it from underneath you, right? So it protects you as well. If you don't have the 5 years or, for Medicaid and you think it's going to be care immediately or you're already in care, there's still things that your family members can do to help protect assets, but it's very important to make sure that you have really well drafted powers of attorney for that. I do have one question I'm seeing here that I'll answer. So at my webinar last week, I mentioned that Roth conversions can be a good long-term care planning strategy. And if I could explain that a little bit. So with what a Roth conversion is, if you're unfamiliar, is when you decide to pay the tax on your pre-tax IRA, 401k, something like that, and then convert the remaining amount over to a Roth. So it's you doing some tax planning, picking the tax rate you're paying on it essentially, rather than having the kids pay it all later on. And you can have that then be a post-tax retirement account. The reason this can be a good long-term care planning strategy is sometimes we have to expedite or move the balance of those accounts over to another, either liquidate it out, move it to a trust, or annuitize it over to a spouse living at home to get the income, make it an income stream for the healthy spouse so they can keep the bulk of it. And you just tend to save more money in the long run when you're not worried about also paying the tax on it when you're doing it. So if you can stretch out the taxes over a longer period of time on, at your own rate in choosing the rate at which you're making that conversion versus we need to do this now, care is, happening and we need to move these assets. You don't have any choice over that tax rate. It's kind of move it or lose it. So the more you can get post-tax, the earlier you can get it post-tax, the more you can save if you have to do any gifting of assets or transferring of assets into like an irrevocable trust or over to a community spouse. If it's post-tax, you don't have to worry about the tax on it at that time. Whereas if it's pre-tax, you're not just worried about, well, how much of this can we save? It's how much of it can we save after we've paid all the tax on the transfer. And so you're always going to be money ahead in that moment if it's post-tax money that you're doing that with. So with a Roth conversion, that's why it can be very helpful for long-term care. And that's a very simple explanation, but a very kind of 1,000-foot view explanation of that. But I don't have a ton of time to get into too much detail on that. But what I would recommend is when you're doing that, if you have a tax advisor, like a CPA, if you have a financial planner, work with both of them on that to make sure you're doing it at the right tax rate, at an efficient tax rate, and that they're involved in that strategy. It's not something I'd expect somebody to necessarily do just on their own. So hopefully that answered that question at least as much as I could in that short period of time. But since I'm out of time here and I don't want to hold you all up too long, just a quick reminder that next week is our Appleton Public Seminar here at the Bordini Center at the Fox Valley Tech. So that'll be next week, and I believe that's March 15th, if I'm not mistaken. The week from today would be March 15th. And there's a 2 p.m. and a 6 p.m. session. So if you want to sign up for that, do so at estateplanningalive.com, or you can call our office and we can help. If you're not as comfortable with the internet, we can certainly help you do that too. And sign up for the session that's easier for you to attend. And again, keep an eye out for that feedback form where you can reach out to us or have us reach out to you to set up an initial consultation that is, again, complimentary. And the handout as well will be a part of that. So I hope you all enjoy the rest of your day, and I hope to see many of you at the in-person Wills versus Trust seminar next week.